Well, goodness, thank you, Randy. It's an honor to be here with all of you and in the company of these other people who have spoken. Again, my acquaintance with Mr. Scopes was pretty short-lived, actually. When he went to trial, of course, I was not born yet. 3 years later, as Randy has just told you, the state of Arkansas the voters there voted in a law very similar to the Butler Act, and forbidding the teaching of the evolution of humankind from a lower order of beings. And so here we are, 1928. As I say, I was not born yet. But some 40 years later, I was teaching at Little Rock Central High School, teaching 10th grade biology, and I was approached by some people who were very active in the Arkansas Education Association to make an attempt to clear this law off the books of Arkansas. There had been some attempts before that. There were attempts in the legislature of Arkansas, which simply did not make it. Didn't get rid of the law. And so the Arkansas Education Association felt that this was detrimental to the teaching of biology, that it was detrimental to the appearance of our state. And so they decided we want to come up with a lawsuit to get rid of this law. We're going to take a different approach from the case, the way it was pursued in the case of Scopes here. They had actually heard that there was a biology teacher in another town in Arkansas who was willing to teach evolution, have himself arrested, and go into trial the same way John Scopes did as a defendant. They decided instead they wanted to attack the constitutionality of the law by having a biology teacher who was under threat from the law be a plaintiff in the case and actually challenge the validity of this law, the constitutionality of it, and say, I intend to teach biology, I ask the court to protect me, basically to declare this law unconstitutional. And so they asked around, as from my understanding at the time, they were asking all the biology teachers around if they were interested. That may not be the case, but they came to me and asked if I would be interested in being the plaintiff in this case. It was an absolutely terrifying thought because I knew it was a very controversial issue, and I knew there were many people who would be very unhappy about what we might be doing. And I said, let me go home and ask my husband, John, and John said, do it, do it. So I met with the Arkansas Education Association lawyer, Eugene Warren, a wonderful man, and the executive secretary for the Arkansas Education Association, a man named Forrest Roselle, and Virginia Minor, who was just one of my fellow teachers there at Little Rock Central. And Mr. Warren showed me the case that he had outlined, basically about a 5-page brief with 5 points describing what were the things that were unconstitutional about this law. Our approach had nothing to do with my faith, my belief. I actually am a believer in Jesus Christ, but that was not what the case was about. It had to do with, was this law constitutional or not? And so once I read that lawsuit and chatted with them a little bit, and actually the lawyer assured me, you're probably not going to have to testify. This is a legal case. It will be decided in the judge's chambers and so on. And so I agreed to be the plaintiff in the case. I realized that the only reason to say no, because I fully agreed with what they wanted to do, the only reason not to do it was just fear. And I decided it was not worth just saying no because I was afraid of the controversy that would come up. So I agreed to be the plaintiff. The case, a few months after this meeting, which was in November or so of 1965, so we're basically 4 decades since the Scopes trial. A couple months later, the lawyer called me and he said, well, you are going to have to testify. The State Attorney General wants to have a regular court trial. There was no jury, but just a regular court trial, and so and of course I was petrified. But I met with Mr. Warren. We talked about the whole thing, and he said, gave me some very good advice, which if you've ever been involved in a court case at all, you've probably had the same thing. He told me, when the State Attorney General asks you a question, just answer the question. Do not elaborate. Do not, supply any more information. If he needs to know more, he can ask. And so I thought that was very good advice. The lawsuit was actually filed in, our complaint basically was filed in December of 1965. The first hearing, which was a Chancery Court hearing there in Little Rock, was on April 1st, 1966. We always kind of took some note of the date that they chose. I did have to testify. Another bit of advice that the lawyer gave me was, if they ask you about your faith, if they ask you questions related to whether evolution is an atheistic concept or not, then wait a minute, half a second, I'm going to object. And in fact, that's what I waited a moment and he objected, and in most cases, because again, that was veering off into an area that was not the intent. And so he would object, and in most cases, the judge upheld his objections. And so testimony as to the faith aspect of this really was not allowed. By mid-afternoon, the Attorney General, because he had gathered a bunch of pastors together to come and testify about the atheistic nature of evolution, because that was not allowed, he really had run out of questions. I can actually remember him standing at his table, kind of leafing through his notebook, and there was just nothing more he could do, because again, there were these objections and they were upheld. And so the trial was over in a day, maybe the rest of the day, the full morning, maybe 2 or 3 hours in the afternoon. And so I was quite relieved, of course. And so I went back to my classroom. Again, still teaching biology at Central. I did miss that one day of class. About a month later, this weekend, 1st of April, 66, about a month later, I got a call actually from a reporter from the newspaper who said, Judge Reed has just decided the case in your interest in agreeing with you that the law is unconstitutional. What's your reaction? Of course, I was delighted to hear that. I knew that was probably not the end of it. But at that moment, anyway, it now was suddenly legal to teach human evolution in Arkansas, which was a rather exciting thought. The Attorney General of the state, whose part of his duty is to defend any state law anyway, but he appealed this decision to the Arkansas Supreme Court. They sort of sat on it for about a year. So again, this was legal for about a year. And in June of 1967, the Arkansas Supreme Court reversed that decision. They did not clarify any of the issues. They did not say why these things that had been declared unconstitutional were suddenly constitutional, which they weren't. But they just reversed the opinion of the original court judge, and so that opened the door for the AEA lawyer to appeal now to the United States Supreme Court, which was the next level in the process. And he did. He made the appeal. We discussed the whole thing, talked about it. I was very relieved to understand that beyond the original court, I did not have to testify anymore. People do not testify at the Supreme Court. The lawyers take the case. But the Supreme Court agreed to hear the case. At that time, because John was in the Air Force, we had moved and we were living in Maryland, outside of Washington, D.C., and so the lawyer called me and he said, I think they're going to be hearing your case tomorrow, between such and such a time, and so if you want to go, which of course we did, which is, whenever I talk about the case to groups, one thing I like to emphasize, that in the United States, we can go to the Supreme Court and we can sit in if you're quiet and don't chew gum. The point is, you can go to the Supreme Court and you can hear a case argued. And we all have the right to do that, which I think is a wonderful thing. So we went to the hearing, and again, it lasted maybe 30 minutes or so. At that point, Arkansas had elected a new Attorney General. The new Attorney General was not quite as zealous about defending the law as the former one had been. And in fact, he sent an assistant Attorney General to actually defend the law before the Supreme Court. And kind of interesting thing about that, he had gone to the same college I went to, a small Presbyterian college where my dad taught, and so we knew each other from college, this assistant attorney general. And so, again, about a 30-minute hearing. It was very interesting to sit in and hear the court. I understand that there was probably a little more laughter in the court than there sometimes is. One of the justices asked this Assistant Attorney General, it appears that the state of Arkansas is not that interested in defending this law because, they said an Assistant Attorney General, and so, of course, there was a little bit of laughter from that. Anyway, after 30 minutes or so, they were finished, and we went home. This was October of 1968. A month later, in November of 68, the court ruled 9-0 that the Arkansas law was unconstitutional. And again, it was essentially the same as the law here in Tennessee. And in fact, during the time that our case was moving through these courts, the legislature of Tennessee voted to essentially repeal the law in Tennessee. So it was already gone. There was another law in Mississippi, and of course essentially the Supreme Court decision had an effect on them as well. So essentially, okay, good, job well done, we're all finished. Well, of course it's not finished, as we all know. But one of the interesting things, a couple of just connections with John Scopes through all of this. At some point, reporters and so forth offered to pay his way to come to court when we went to court in Arkansas on April 1st of '66. And this really just fits along with what we've already been hearing about his personality. When I think of him, the little bit that I know of him, the word humility comes to mind. He did not make a to-do about his part in this case, and he realized, he actually wrote a letter to, of all people, Jerry Tompkins, saying, I will not take up these offers, I will not go to Arkansas for this hearing. I don't want to detract, I don't want to contribute to any kind of a circus-like atmosphere. Our trial was far more boring than the case that was held here. But he did not come. After the decision in November of 1968, Jerry telephoned me and said, would you like to meet John Scopes? And I said, yes. And of course he was living in Shreveport. My grandmother lived in South Arkansas, near the town of Camden, if you know that, but she lived in a town called Chittister. And we were there for Christmas, and so it was not too much of a drive to come down to Shreveport. And so my father, who was a biology teacher, and my husband John and I drove down to Shreveport and had lunch with Mr. and Mrs. Scopes. And it was just a fun event, just very, again, low-key, just a nice visit. One thing that was really nice about that is he assured me verbally himself, I agree with everything you were doing. I'm with you all the way. I'm behind the effort you made. I knew that it would detract from what you were doing if I tried to go myself. and basically sort of apologizing for not showing up. Well, I certainly understood, and I appreciated that. And so, it was, a year and a half after that he passed away. But it was a privilege and an honor to get to meet him. I feel that he, as well as I, believe that one of the objectives in education is to educate, to help people to learn about the truth, about the world, about what we know, and certainly in science it's very exciting, and to then move forward with that knowledge and that understanding, and of course make their own decisions about things. But good decisions, and it can't be very made if we're not educated. And so he believed in that, and I do too. I did too, and I do too now. So thanks for the honor of being here. Thank you.